afternoon, everybody, and welcome to this second webinar in Seals and Betterage's series for anybody who's going through a separation or divorce. In this session, we're going to talk about how you can start to sort out your finances. And that we know that that can be complicated and painful, especially perhaps if you've been married a very long time. So presenting with me today is Lisa Kellett, who is Head of Matrimonial Finances at Seals and Betteridge, and I'll ask her to introduce us properly in a second, but I don't think we could be in better hands for this webinar. A little bit of housekeeping before we start. You'll see at the bottom of your screen there's a Q&A button. If you would like to ask any questions, please put your questions in the Q&A. Only Lisa and I can see the questions, so that will make sure that you remain anonymous watching the webinar. We will try and get through as many of the questions as we can. So, Lisa, would you like to very quickly just introduce yourself, and then I'll take over and introduce myself and do my little presentation, and then yours.
Okay, thanks, Claire. Hi, everyone. My name's Lisa Kellett. As Claire's just pointed out, I head up the Matrimonial Finance Department at Seals and Betteridge. I work between the Lincoln and Nottingham office. I am a partner in the firm. I'm a solicitor. I'm 29 years qualified. I am accredited by resolution in financial proceedings, and I specialise in financial proceedings arising from breakdown of all relationships, not just marriage.
Thank you very much, Lisa. So as I said, I don't think we could be in better hands today. I'm going to share my screen very quickly. There we go. So just to introduce myself, my name is Claire Macklin. I'm a breakup and divorce coach. I've been doing that now for about 6 years. I'm a master NLP practitioner. I'm a former lawyer myself. I've been divorced twice now. The first time was a very sudden shock, which a bolt out of the blue 15 years ago. And the second time I made the choice. So I've navigated my way through divorce and separation from both perspectives, if you like. I'm also a single mum to 2 boys. The oldest just gone to university, and he was 3 when my first marriage broke down. So I've been a single parent, a single mum, and a co-parent for a very long time. And I'm also the author of a book, Breakup from Crisis to Confidence, which takes you through the journey from day one of a sudden breakup right through to creating the blueprint for what you would like life to look like afterwards. So all of my coaching work and these sessions are geared to help you do 7 things. I call these the 7 C's, and they really are the foundation for all the work that I do as a coach in this area. So first of all, to help you concentrate on you, I know how tempting it is to focus solely on your ex-partner, what they're doing, how they make you feel. But I help you to turn and shift your focus onto yourself so that you can look after you and focus on what you can do. And becoming calm, so strategies to stay calm in a really turbulent time. To get clarity, so what information you need, knowledge, clarity around the things perhaps that scare you. And we'll talk about that a bit more today. To focus on what you can control, so controlling the controllables, that's where your power lies. Seeing options and choices, so the choices that you make now about how you behave, how you show up, what you say, what you do, the decisions that you make will all have a really big effect on what the future looks like. And then communicating more effectively so that you can say what you need to say, so that you can communicate hopefully with less conflict. And then finally, to create a vibrant and exciting future that you're pleased to live. So today we're going to talk about the finances on divorce in particular. And I know from working with hundreds of clients and from my own experience, fear of the financial future is one of the biggest issues that my clients sometimes bring to sessions. And it can really send you into a fight, flight, freeze fear response. So some of the things that I hear and perhaps you're feeling right now, I won't be able to support myself and the children. I'm worried about my financial security. Or perhaps I'm worried that I'm going to have to give half of my assets to my ex-spouse, or our settlement won't be fair. Or perhaps you're worried that you'll lose some of inheritance, perhaps that you might have received. Perhaps you're worried about how to sort out the business that you run together. We'll talk about that later too. Or maybe you're worried about the costs of your divorce and that all of your assets will get eaten up in the costs, court fees and solicitors' fees and so on. Perhaps you're worried that you won't be able to stay in your home or that you have no control over the outcome. Or perhaps you're the person in your relationship who doesn't have all the financial experience, and perhaps you feel that you don't know as much as your ex-spouse. So there are lots and lots of fear around divorce when you're going through a separation. So I want to look at fear first of all. There are 4 ways that you can handle fear. You can get over it, you can go under it, you can go around it. But if you're ever going to be able to put fear behind you, you need to be able to go straight through it. This always reminds me of the Bear Hunt books. I don't know if any of you have ever read those to your children, but there's a line in it: you can't go over it, you can't go through it, you've got to go. You can't go over it, you can't go around it, you've got to go through it. And there's a really lovely Buddhist story that I often share with my clients around this. So once there was a young warrior, and her teacher told her that she had to do battle with fear. She didn't want to do that. It seemed really aggressive, it was scary, and fear was really unfriendly. But the teacher said she had to do it and gave her the instructions for the battle. So the day arrived, and the student warrior stood on one side and fear stood on the other. The warrior was feeling very small, and fear was looking really big and wrathful. Both had their weapons. And the young warrior roused herself and went towards fear, bowed 3 times, and asked, "May I have permission to go into battle with you?" And fear said, "Thank you for showing me so much respect that you asked permission." And the young warrior followed this up with, "Well, how can I defeat you?" And fear replied, "My weapons are that I talk fast and I get very close to your face. You'll get completely unnerved and you'll do whatever I say. But if you don't do what I tell you, I have no power. You can listen to me, you can have respect for me, you can even be convinced by me. But if you don't do what I say, I have no power." And in that way, the student learned to defeat fear. So what do I take from this story? Well, fear might be there to warn you. It can be intimidating, it can be scary, but ultimately, if you don't do what it says, it has no hold over you. And when you face a fear head on, it reduces its power over you. When you avoid or give in to a fear, you increase its hold over you and give your power away. Lisa, I don't know if you do you know where the mute button is? If you could put yourself on mute, I think there's a bit of feedback. Perfect, thank you very much. So it's always better to know where you are than to live in the shadow of what if. So getting clarity can really help you cut through the fearful thoughts. So for example, my slides are not moving now. There we go. Getting clarity around the things that scare you is the best antidote to overwhelm. So some of your fear might arise from lack of knowledge. It helps to get clarity around those fears. So the unknown is really scary because you don't know what it looks like, and you can start to create all kind of what if scenarios. And it's better to know where you are than to live in the shadow of those what if stories. So for example, you may need to get legal clarity around what you can and can't do, around what a potential settlement might look like, any other legal questions you might have, timescales perhaps, or procedure. Ask any questions. There is no such thing as a stupid question in this scenario. Read up, educate yourself, get as much information as you can. In terms of your finances, fear of an unknown gap or an imaginary hole in your finances can often be more frightening than actually knowing if there is a gap, and if so, how big it is. Because once you know how big the gap is, you can start to work out ways to fill it, whether that's returning to work or negotiating a different split on settlement or starting a new business. And you'd be surprised how many of my clients have done that. Or perhaps by cutting back on spending in particular areas. So when I have a client who's really overwhelmed by fear and uncertainty, I often use this exercise with them. The first thing is to get a big piece of paper, brainstorm all your fears onto that big piece of paper. There's something about taking the worries in your head and writing them down with your hand rather than with a computer that helps to get those fears out of your head and onto the page. So take your time doing that. Write down anything that comes to mind. Don't worry about details, just jot down anything you can think of. And then notice how those fears make you feel. So where do you feel that? Do you feel it in your belly? Do you feel it in your chest? Perhaps you feel it in your head. And allow yourself just to sit with that for a couple of minutes, noticing how it makes you feel. So you've identified your fears and you've acknowledged them. And then notice where your fears and worries and those feelings lead your thoughts. So perhaps your mind starts to go off in all sorts of different directions. Perhaps you find yourself in a downward spiral of internal questions. When that starts happening, the first thing to do is to breathe and count. And I showed you this in our last session. So breathing in for 5 and count as you do it, hold for 2 and breathe out for 7, counting while you go. Do that about 3 or 4 times and you'll notice that your heart rate will start to come down. It will interrupt the thoughts because you can't count in your head and think all at the same time. And then you can start asking some really empowering questions to help you get unstuck. So some examples of some really good questions that you could start to ask. And I actually stuck these up on my fridge when I was going through my first divorce, and I often advise my clients to do the same. Who could help me with this? And who do I need in my support network? So do I need to speak to a financial advisor? Have I got questions that I need to ask a lawyer? Do I need to speak to a friend about how they coped with this when it happened to them? What do I need to find out about to get clarity around this? So where are the areas that I'm unsure about? What don't I know? And what can I control here? It's a really important question because when you focus on the bits that are out of your control, you are likely to feel much more overwhelmed. So work out what you can control and focus on those bits. What skills do I have that could help me right now? And have I ever dealt with something similar before? What did I do? So think back, have you dealt with something really challenging before? What resources did you use? What skills do you have? Perhaps some of your work skills might be helpful. What resources and strengths and skills do I have that would help? And then finally, what is one small step that I could take today to help me? And you could think of one small step perhaps for 3 or 4 of the different fears that you have. Once you've done that, then focus on taking one step at a time. It's really important to make sure that the steps you plan to take are manageable. So one step at a time over a day, a week, a month will add up to big leaps forward. So just focus on the next step and then the next step and then the next step, rather than trying to get to the end right at the beginning, because that will be really overwhelming. So just to give you an example, if your future financial position is really uncertain and it's worrying you, there can be so many what ifs that you feel really overwhelmed. So what information do you need and who could help you find it? So perhaps you might decide to start with your current situation. So your first step might be to go to your bank statements. You could then add up, first of all, your total monthly income, then your total essential spending, i.e. all the things that you're obliged to pay, your bills, etc. And then your total discretionary spending. So all the stuff that you choose to buy, all the things that you choose to spend your money on. And then from there, your second step might be to work out a budget. And your third step might be to think about where you could change your spending or where you could prioritize differently. And even if the picture isn't quite as you would wish, at least you're no longer in the scary position of not knowing. Once you're aware of any shortfall, then you can work with the facts rather than the what ifs, and you could start to plan. So I worked with a client a couple of years ago who was terrified to even look at her bank account. It was in a total mess. However, once she did do it, she was able to make some savings. So she phoned her bank and she arranged a mortgage holiday. And she took a leased car back, which saved herself hundreds of pounds almost immediately. And it gave herself time to work out a plan. So one step at a time. The next thing I want to think about is strategies to help you respond rather than react. Because when you are entering into negotiations about your finances, it can be really frightening. It maybe makes you feel a bit panicky. And fear can lead you to responding instinctively and through a fog of fear or emotion. And when you respond through a fog, you're much more likely to respond quickly and without thinking. And in a divorce, that can lead you to say things you might regret later, or perhaps make decisions that aren't in your best interests. So I just want to share three really simple strategies that you can use just to slow down your instinctive fear-based responses. The first is this mantra: stop, breathe, think, respond. Repeat this to yourself whenever you feel those emotions rising. Stick it on post-it notes around your house. Take it with you in your handbag if you or your bag if you need to go to a meeting. Because when you stop and breathe, you give yourself space. You bring oxygen back into your brain, which helps calm the emotional threat response. And your breath has the power to overcome that immediate stress response that might otherwise cause you to act without thinking. Even stopping to take just 3 deep breaths before responding will give you just that moment to pause and think and consider your choices before you act or reply. And it can also give you time to remember that you don't have to respond to your ex's proposals, perhaps around your finances, in the moment. Take your time, take advice, talk to your financial advisor, talk to your solicitor, find out what any proposal might actually mean in reality for you. And then sleep on it. Give yourself 24 hours. So when you sleep, your brain processes the events of each day, and giving your brain time to do that is really important. Most of the correspondence that you'll receive doesn't require an immediate response. And the decisions you're going to need to take now will affect your life going forward. So it's really important to take your time to consider them. Don't feel that you need to be rushed into making decisions straight away. And I always advise leaving 24 hours between receiving an email, perhaps, and sending a response if possible. So sleep on it. Don't be rushed. Don't feel like you have to give an immediate response. And then focus on what you can control. So these bits in this blue zone in the middle are what you can control. So you can control your stuff, your words, your actions, your behavior, your decisions. You can't control somebody else's. And I call the blue zone in the middle the blue zone of power, and the orange zone around the outside is the orange zone of frustration. Because when you try to get your ex-partner to think differently or behave differently, oftentimes they won't, and you'll end up feeling frustrated. So rather than thinking, I wish I could get my ex-partner to understand, instead focus on thinking about what you're saying and how you're communicating what you want to. So practice perhaps saying what you want to, get on top of your numbers, take the advice that you need to make really good informed decisions. And when you communicate, avoid saying things like, you always do this or you never do that, because those are bound to elicit a fairly defensive response. So instead, shift the focus back onto yourself and what you would like. So some examples might be, and you could prepare some of these things to say so that you practice them before you need them. I need some more time. I'd like you to explain that again, please. I didn't understand what you just said. Could you say it again? Or I heard you say X. Have I understood that correctly? Or I'll take advice and get back to you. Practice some of those lines so that you've got those to say when you feel under pressure. So what if you own a business together? So divorce is stressful at the best of times, and when you own a business together, it can be doubly so. And your business may be your most valuable asset, of course. So there are all sorts of losses here. You may be facing the loss of a marriage as well as the loss of future dreams that you might have had. And perhaps you work very closely together too. So some ideas about how to handle that. First of all, get clarity, legal clarity, financial clarity. You're going to need detached, independent advice, and get clarity on the choices that you might have, the possible ways forward. There are lots of ways to deal with a business on divorce, and it's going to be really important to have clarity around the choices that you might have, depending on the size of your business, the type of your business, and of course, whether you wish to continue to run it together or not. And you can choose a solicitor who has experience in that area. And that's going to be really important too. So when you own a business together, I think it can be quite helpful to almost think of the business like you might as a child. So conflict between you is going to be damaging to that business. So ask yourself, what is in the best interests of your business? Um, the business is valuable, it's possibly your largest asset, so it needs protecting. Whether you're selling it, exiting it, keeping it running pending a sales process, or planning to keep on running it together, you're going to need strategies to respond rather than to react. So, some questions that you might like to ask yourself: where can we find common ground? Where can we agree? Because the more you can agree on, the less it's going to cost you in fees. If you're continuing to work together, how can you make that work? Do you, for example, need to have separate workspaces? Do you need, for example, to have meetings over Zoom rather than face to face? And how can you define your roles clearly so that you minimize misunderstanding? So, defining your roles clearly, it's going to be really important to set clear boundaries. Who is doing what? Um, what is your role? What is your ex-partner's role? And be really clear about them and explicit. You may even want to consider perhaps writing a written contract. Focusing on where you can agree is going to really help you, rather than focusing on the bits that perhaps are more contentious. Be clear on your goals and take advice if you need it, and perhaps bring in a mediator or somebody to help you have those discussions. And a really important thing to do is to think about standing in the other person's shoes. So I often do this exercise with clients. So I will ask my client to stand in their shoes and tell me how they feel and what they see and what they hear. And then I'll ask them to literally shake that off and stand in their ex-partner's shoes in a different part of the room and look at it from their perspective. And it can be really interesting what comes up. I ask them to pretend to be their ex-partner and describe what's happening and how they feel from their perspective. And then I ask them to stand in a third position as an independent person looking in. And I ask, what advice would you give these two people in these circumstances? And that can be a really helpful exercise to go through to help you start to see things perhaps from your ex's perspective so that you can perhaps negotiate more productively. Keeping the personal and the professional separate is going to be really important. So there are some really practical things you can do to help yourself do this, even down to wearing different clothes. So different clothes for going into work as opposed to what you would wear at home. That will help you to keep the different hat on. So when you're in work, you've got your work hat. When you're at home, you have your personal hat. And you can shake off when moving between roles. And I literally mean standing up and shaking your body off when you're moving from your workspace into your home space. Breathing, again, is going to be really important to bring that calm. And it can also be really helpful to remind yourself what the other one of you brings to the table, to focus on the things that that person does well, rather than focusing on the things that they do, in your opinion, badly. And that can be really easy to fall into the trap of. So trying to keep the professional at work and the personal at home, and keeping the end goal in mind all the time. And then just before I finish, I want to just talk a little bit about this, because I hear this a lot. I've lost track, in fact, of the number of times that a client has said to me that their ex has said something to them along the lines of, you said you wanted to be amicable, but now you've instructed a solicitor, it won't be. Sometimes this might be said out of fear that instructing a solicitor will somehow make your divorce more acrimonious. And sometimes it's used as a threat to make you agree to a proposal that actually might not be fair. Either way, financial disclosure is just a part of the process of divorce. Sills and Betteridge are regulated and belong to Resolution, who have at their heart the wish to provide people with routes through divorce that are amicable and that are resolution focused. So, you know, this is not going to instruct a solicitor does not necessarily mean that your divorce is going to become more acrimonious. Actually, it means that you'll have the information that you need and the knowledge that you need to make informed decisions. So asking for financial disclosure is something that you need to do. It's not a greedy thing to do. It's not an aggressive move. It's simply part of the legal process that you need to go through. So that brings me to the end of what I wanted to say. I shall stop my share. Perfect. And I will hand over to Lisa, who's going to talk a little bit more about the legal aspects of this. Thank you, Lisa. Lisa, I can't hear you. I don't know about anybody else. I'm not sure why. See if we can hear you now. No. Looks like you're on mute now, Lisa. Oh, there we go. No. Maybe you need to check, Lisa, which microphone. I don't know. Is there an IT person there who could have a quick look?
Am I okay now? Can you hear me?
Yes. Yes, I can.
Oh, brilliant. Okay,
Perfect.
thank you very much. Thanks, Claire. Apologies for that. Just following on, I think, from your last slide, I think one of the things I forgot to say when I was explaining what I do, as far as Sills and Betteridge are concerned, I'm also an accredited mediator, and I am going to touch upon mediation later on with my slideshow. But at the moment, we're going to take somewhat of a whistle-stop tour with regard to the financial process. So how to obtain clarity around the finances. Initially, I would always see my clients for what's called a preliminary advice meeting. And even at that first stage, we would be information gathering. So I would speak to my client, see what they know about their financial situation, and perhaps see where any gaps lie in their knowledge, because that will flag up to me potentially what information that I might need from the other party. If financial proceedings are issued, then the first thing that the court order is that parties file what's called Form Es. And it might be interesting to have a look online if people who are listening or viewing today haven't yet done their financial disclosure, because the Form E details what information is required. We would normally, in any event, provide all clients with a list of financial information that we need. And in every preliminary advice letter that I send, we would always say, well, we need full financial disclosure. But as I say, if we go to court, Form Es are used. The court order that both parties complete Form Es, and the Form Es would include details of all properties, income, capital, pensions, debts, information with regard to companies, etc., etc. So in that respect, they are very detailed. We often use Form Es, however, even when we are looking at voluntary financial disclosure, because it just provides us with some structure. And it also means that if matters do proceed to court into the future, in some respects, it's easier to update a Form E than it is to start from scratch. And it's also sometimes cheaper for clients to do that. One of the thorny issues is always, or a lot of the time, there may be issues that your spouse does not make full disclosure. We get either voluntary financial disclosure, or through the court process, we have an exchange of Form Es and there is information missing. You'll often find me poring over bank statements from other parties to just check whether or not there are any transfers into either in or out to accounts that haven't been listed, looking at any potential purchases that parties have made that are relevant, looking at any transactions that are relevant, for example, cryptocurrency, and perhaps other assets that haven't been disclosed. If you're in court proceedings, then, and even outside of court proceedings, we get to ask questions. So, for example, looking through bank statements, there is an account where we can see in the last 12 months, because 12 months bank statements is what, at least what needs to be produced, we can see that there are transactions to another account that hasn't been disclosed. Of course, we would ask a question about that. If we were in court proceedings, it would be in the form of a questionnaire. If the other party still refused to answer that question properly, we can look at what's called a schedule of deficiencies, go back in front of the judge and say, we've asked the question, it hasn't been responded to, it needs to be responded to, or the court needs to draw some adverse inferences from that. Pensions are always fun. How are these dealt with by the court? And I think if I look at the Pensions Advisory Group report of 2019, what happened prior to 2019 was that any pensions that usually accrued outside of the marriage were what we call ring-fenced, taken out of the pot, and only pensions that accrued during the period that the parties were married or living together and subsequently married were taken into account by the court when looking at any pension share. Everything changed, however, with the Pensions Advisory Group report of 2019. And from then on, the court say, well, no, we're not automatically ring fencing any pension that's accrued outside of the relationship. What we are looking at is need. And so what the court invariably look at is how to equalise pension incomes into retirement. And thereafter, it's only if those pensions produce more than the other party needs that the court will look at discounting perhaps some of the pension that has accrued outside of the relationship. One of the experts that I invariably use a lot is a pensions expert on divorce, on the basis that if we are looking at calculations as to what percentage of a person's pension is required to equalise pensions into retirement, or perhaps looking at a situation where one of the parties is having more of the available capital and therefore will have a smaller share of the pension, which is called offsetting, then these are calculations that are usually undertaken by a pensions on divorce expert who is actually an actuary. And we have various firms of actuaries that we use for that purpose. If matters are within the court arena, then depending upon the value of the pension, usually anything over £100,000, or a defined benefit pension, which is, for example, one of the local authority pensions, armed force pensions, or any pension that produces a guaranteed amount into the future, then the court will say we need to use a pensions expert on divorce and they need to produce a report. The expert is usually jointly instructed and the fee for the expert is shared equally between the parties. But once again, we would always suggest, provided that the pensions are of some value, that a pensions expert on divorce is instructed so that clients are properly aware of what they should be getting with regard to the pensions that have accrued either during the relationship or even now post pensions advisory group report after the relationship, prior to the relationship or after the relationship has broken down. As I said, I am an accredited mediator. When to attend, that's very much a decision that parties make. I see some parties who have had no financial disclosure yet, who want to deal with the whole process through mediation. And so the financial disclosure process is dealt with by the mediator. Sometimes I see clients who have already had the financial disclosure process and negotiations have broken down, and their solicitors have sent them to mediation in an attempt to avoid court proceedings. So general principles of mediation, we are looking at an alternative to court. The advantages over court proceedings is that mediation is quicker. I think at the moment I deal with mainly the Lincoln and Nottingham courts, and I'm often saying to my own clients, when we're looking at potential financial proceedings arising from the divorce, that they need to batten down the hatches for probably up to 12 months, because realistically that might be the time frame that they are looking at for the court to make a decision. So mediation is quicker. Of course, it's cheaper. Again, the costs of litigation, no one can get around this. The costs of litigation are significant, and it leaves decisions in the hands of the parties rather than potentially with the court. So discussions can take place. Discussions can take place openly, and if a agreement can be reached, then solicitors can then be re-instructed to draft the financial order, and at that stage the agreement becomes legally binding. But again, it is much quicker and much cheaper than the alternative, which are unfortunately court proceedings. And again, I think going back to what Claire said about solicitors and them trying to make money and them perhaps ratcheting up issues between parties, what we always try to do, and what I always try to do, is perhaps think outside the box. Even if mediation may not be suitable for particular clients, and it's not a process that all clients want to embark upon, it means that a client is with their former partner in a room with a mediator. Sometimes clients don't want that, but we try, as I say, to think outside the box, look at roundtable meetings, look at potentially arbitration, which is a different form of alternative dispute resolution, but where the arbitrator makes a decision that you are then bound by, but you are legally represented during that process. So it's not just either mediation or litigation after negotiation. There are other ways that we try and resolve these matters, and which would still be satisfactory to our clients. Do I need a clean break order? So if financial matters are agreed, should that be ratified by way of a clean break order? Simple answer to that is absolutely yes. I think everybody has read in the papers nightmare cases where parties thought that financial matters had been agreed a number of years ago, financial circumstances change, and then the former spouse comes back and says, well, we didn't have a clean break order within our financial proceedings, so within our divorce proceedings, and so all my claims against my former spouse remain open, regardless of whether or not the divorce has been finalised. So if there is an agreement, it should always be ratified by way of a clean break order. And again, from experience, I've had clients who have transferred a property into their sole name, already paid out their spouse or ex-spouse, and a number of years later, the ex-spouse has come back into the picture and said, I didn't get enough at that stage, I now want more money. And because there wasn't a clean break order made at the time, perhaps parties were doing their own divorce and didn't look at obtaining a clean break order, then it's left the person with the house in a very precarious position. So always obtain a clean break order if finances are agreed. And even if they're not agreed, think about, as I say, if mediation isn't successful, do I need to make an application to the court for a clean break order, even in circumstances where there aren't significant assets? It just ties up all of the loose ends and means that you can move on with your life without any concern that if your financial circumstances change into the future, then your ex-partner is going to come back and make some form of claim. The remarriage trap. Interestingly, I saw a client today, and this was relevant to them. What happens is if you are respondent in divorce proceedings and you then remarry without dealing with the financial aspects of the marriage, or having made an application to the court to deal with the financial aspects of the marriage, then you cannot go back and use the Matrimonial Causes Act, which is the usual act that we use to make a claim against your former partner. It's somewhat complicated because the applicant, or the old petitioner, as it were, in the divorce, has already made their claim in the divorce petition or divorce application. So they are fine. But if you are respondent in divorce proceedings, you are considering getting remarried, but you haven't yet resolved financial matters arising from your divorce, then please bear this in mind, because it may affect the claims that you actually can make. We can use other provision with regard to property, the Law of Property Act, but just bear this in mind, because really this should be dealt with, the finances should be dealt with if you are respondent in divorce proceedings and you are thinking about remarrying. And the last thing that I'm going to say is, please don't forget about your will. If a property is owned in joint names as joint tenants, and many either cohabiting parties or married couples own a property in that way, that means that should either of you die, your share of that property automatically reverts to the other, which I think during a relationship is absolutely fine, and no doubt that's what you would want to happen. Post-separation, however, that might not be what you want. And we always advise our own clients in those circumstances, sever the joint tenancy. It's just serving a notice on the other party. It means that your share of that property will then pass through your will rather than automatically to the other party that owns the property. But that means do not forget to make your will, keep it updated. And in any event, you need to think about making a will if you're looking at testamentary guardians for children, for example, or you're looking into the future as to what you want to happen to your assets post-divorce. So it's really important to bear that in mind. And I think we are now going to go to questions, I think, Claire, right?
Yep, there's a couple of questions to ask. So first of all, thank you very much for that, Lisa. Hopefully that has given listeners some clarity around the processes. So the first question, in a divorce, if the applicant is divorcing the other person and it turns out that they have been having an affair in the marriage, does that change the court outcome, i.e. where one person has been lying constantly? I think I know the answer to this, but I'll refer to you, Lisa.
Thanks, Claire. I think as of last April, all divorce applications are no fault based. So prior to April, if you wanted a quick divorce, you would have to have grounds for either adultery or unreasonable behaviour. From April of last year, the whole landscape of divorce law changed, and we now look at no fault divorces. That is the only option that all parties have got. So regardless of the reason for the breakdown of the marriage, all that you have to do is tick the box on the form and say that the marriage has irretrievably broken down. The other party does not have any defence to that. And the court really look at every case on its merits with regard to the finances, but it wouldn't be usual for the court, for example, to take into account adultery as part of the overall financial settlement.
Thank you. There's a second question. So somebody is asking about how to deal with an uncooperative spouse during mediation. So a spouse who's perhaps hiding assets or making false accusations or statements and trying to frustrate the process. Should mediation continue, or is it better to refer this back to lawyers?
I think mediation is a voluntary process, and if there is an issue with regard to the financial disclosure that has been given by the other party, then usually I would refer matters back to solicitors, because it may be that the only way to get full financial disclosure in those circumstances would be by using the court process, because it gives you a little bit of teeth, and it ensures that the court can order disclosure of assets that you feel haven't been disclosed, if necessary. So I think usually those problems in mediation, I think as a mediator, I would be saying to the other spouse, well, we've got issues here. If you don't disclose this information, your partner is going to go to court. So you either disclose it within the mediation process, or you disclose it within the court process. But again, I think in those circumstances, if there were real issues about the disclosure, I would probably be advising my mediation clients to go back and speak to their solicitors, because any agreement reached at mediation is only legally binding when it's made into a court order. And what invariably will happen is that as soon as solicitors will see the agreement that might have been reached on the basis of not having full financial disclosure, they will unpick it anyway. So I think probably in those circumstances, all roads may lead back to having legal advice.
And there is definitely in my experience, I've had clients in this position, and sometimes, you know, the threat of court proceedings being opened and so on is enough to bring somebody to the table for at least negotiations through lawyers, if not mediation. So
Absolutely.
thank you. There's a few more questions. So if I've changed my will to state that my home goes to my children, and there's a provision for I'm not quite sure to stay in the property for 6 months following death, should this provision be removed from the will?
I think
there might need to be some individual.
So I presume in those circumstances, the joint tenancy will have been severed, which I think is what I was talking about with my last slide. So the joint tenancy will have been severed, which means that should one party die, their share passes through the will. So that would mean that the other party's daughters inherit his half share of the property. And obviously that is then dealt with through his probate. So if it's no longer agreed, or if any clause in your will is no longer agreed, I would suggest that you go back and speak to a solicitor about changing that if it doesn't actually reflect what you would want to happen. It does take a while though for probate, etc., to be granted, for the estate to be administered. So I'm not sure whether or not that would take you over the 6-month period in any event.
Thank you. Okay, so do I have to go to mediation if my spouse was abusive?
No, is the answer to that. There are certain exemptions from mediation. One of them is domestic violence. There are, however, different options. So it's not that you always have to mediate in the same room. We can do what's called shuttle mediation, which is where parties are in different rooms and I would move between the two rooms. And to make sure that everybody feels safe in those circumstances, I would always make sure that parties arrive separately. So one arrives significantly prior to the other one, so we're not bumping into each other in reception. They would always be put in a room as far away from their spouse, ex-partner as possible. And then I would make sure that they leave first as well, so that they're always safe. So although probably a joint mediation session in the same room, we wouldn't be looking at that. You could still consider in those circumstances more of a shuttle mediation arrangement.
Yeah, and of course you can always you can use your lawyer as well for legal advice, can't you, alongside mediation, so you can take things back and take advice and so on in between sessions and things like that too.
Absolutely, your lawyer is always in the background. The mediator's not there to legally advise at all. As a mediator, I can give information. I'm not sitting as an arbitrator. I'm not sitting as a district judge. And if there are any legal questions, or if parties reach a stage where they may be saying to me, well, what do you think? What do you think I should get? What do you think I would get if I go to court? My answer to that is very much, I am independent in this process. And those are questions really for your own solicitor. I think, again, what I would say when I see mediation clients initially is speak to your solicitor. Ask them, you know, what the sort of parameters may be. If you go to court, what's my best case scenario? What's my worst case scenario? And if you know where that might be, As long as parties perhaps fall somewhere within those parameters, then they're normally okay, because they haven't had the uncertainty of litigation and they haven't had the cost of litigation.
Absolutely. And I do quite a lot of work with clients around preparing for going into mediation meetings and court hearings as well. But in terms of preparing for those meetings on an emotional level as well. So part of that is getting that clarity that you need. And part of it is going into those sessions with strategies to be able to keep cool, keep calm, be able to say the things that you want to. So there is support out there if you're looking to go through the mediation route. There's one more question, which is, if one party is permanently in debt and the other is not, would this potentially change the 50-50 financial split?
I think, again, it would depend really as to what sort of debt it was. If you have got a spouse who has got a gambling addiction, for example, and has gambled a significant amount of capital away, either during the relationship, post-separation, then it may be something that could be brought to the court's attention when looking at the various factors they consider when they are trying to reach a decision as to what percentage share of assets should be given to each party. I think usually with regard to the 50-50 split, of course, that's a starting point for the court, but the court can move away from that, and the court look at housing needs, they look at the age of the parties, they look at contributions, they look at pensions, they look at conduct in certain circumstances. So perhaps that might be conduct that the court would look at, or it may have impacted upon the available capital that would meet the parties' needs. So there could be some relevance there of the debt situation. The court as well will look at, well, is it matrimonial debt? Did the other party benefit from the amount that was borrowed, etc., during the marriage? And if the answer to that is no, then the court will say, right, okay, well, that's the debt of the other party. You know, we don't necessarily take that into account. So I think the circumstances and what the debt relates to are relevant, I think, to the answer that we could give to that.
Yeah, I think what that goes to show is that all of these, every case will turn on its own facts, and that it is really important to get, as it takes us right full circle back to where I started, which is get real clarity on your position. So rather than talking to your friend down the road whose divorce went a certain way and another friend whose divorce went a different way, actually go and get advice on your specific circumstances from a solicitor, get specific financial advice on your circumstances, so that you're making decisions based on your circumstances rather than somebody else's or anything else that you've heard. I think that's us answered all the questions that have come in the Q&A, and it is spot on 2 o'clock. So all that remains really is for me to say thank you very much to Lisa for her sharing her expertise today, and to remind you that our next webinar is going to be on Wednesday, the 25th of October, where we're going to be looking at supporting children through and beyond divorce. So hopefully many of you will be able to join us there. And we'd both like to say thank you very much for coming along.
Thank you.
Thank you.